in the Regional Processing Centre before transitioning into community accommodation, and that community accommodation is managed and provided by the Government of Nauru.
Are the people who are being transferred to Nauru under the most recent arrangement, are they being transferred to the Regional Processing Centre?
No, this arrangement has no relationship to regional processing.
Senator Shoebridge, I'll have to hand the call over.
Yeah, my last question is, what, if any, costs has Australia incurred in relation to the Regional Processing Centre since 2022?
So, Senator, when we're talking about regional processing, I think we agreed earlier that that was part of outcome.
Do you have the answer?
2. We'll see if we have any information available to us to assist you.
Come back to us if you do, otherwise...
I think one aspect of it was under outcome 2. I think it's still covered by outcome 3, the regional process.
If you can assist.
We'll assist if we can,
I'm sure you
Senator.
will. Senator Patterson, you have the call. We're going to a break at 9, so you'll take us through to there.
I have questions about the NZYQ cohort, and in particular about the community safety orders. Ms Sharp, I suspect this will be one for you. How many community safety orders has the Minister for Home Affairs applied for?
Senator, no community safety orders have been applied for yet.
Right. So you will remember the many times we've discussed this issue in the past, most recently in November 2024, in which you said, and I quote, "We anticipate the Minister will apply for the first order in the coming weeks." That was 16 weeks ago. What is the hold-up for the first application?
One of the most challenging aspects of putting together these cases is how fluid the cases themselves are, as in the people are in the community and their facts are constantly changing around you. So I believe what I said at, just for, you didn't ask to put this to me, but I do believe what I said at that hearing was true. To the best of my knowledge at that point in time,
I'm sure it was. I'm not suggesting otherwise.
But the facts change, and these cases are some really complex confluence of mental health and criminal offending, and so the case was delayed. Or the case, those front runner ones have been delayed a bit. Getting them once we kind of re-establish facts. We then need to collate the evidence because of the exculpatory evidentiary requirement. We then need to make sure we've got completely up-to-date records and sometimes send them back round to the expert again. It's hard to overstate how painstaking the process of putting one of these applications together is.
Sure. As you know, and as I put to you previously, it's not the first time that someone has said that an application was imminent. The former Minister for Immigration, Mr Giles, in May 2024, said that there were 6 cases before the expert review stage, which is the last stage before a matter can go to court for a court to make an order of preventive detention. And he said there were 26 in an advanced stage of preparation. I mean, that was May. We're not far away from a year on from when that statement was made. Do you think the Minister misled the public with that statement?
The only thing I would say, and I think we've brought to this committee's attention before, that in the sister scheme, in the high-risk terrorism offenders scheme, it took over 3 years to put together the first application. I think we threw everything we could at doing this as fast, and we were ambitious. I think the longer we're rolling this out, the more we're getting to understand that 3 years and why it did take so long.
And so Mr Giles' evidence, Senator, was correct. Not his evidence, his statements were correct in that there were a number of cases that were at the expert review stage. There were many more which were at an advanced stage, by which he meant for which we had sent out and were processing all of the requests for information relating to those cases. What we didn't know at that time was what Ms Sharp has just explained to you, just how challenging it would be for us to pull all of that together.
So the Minister for Home Affairs on the 16th of February said there are no cases for preventive detention that are nearly ready to go. Is that statement correct?
The threshold for preventative detention is really high. So when I've been talking about orders with you, I have been talking about both types in my mind, both types of orders. He was correct that there are no cases that I'm aware of that are very close to being filed that relate to preventative detention. The ones that are more advanced do relate to community supervision orders.
So we've gone in May 24 from 6 that were almost ready and 26 at an advanced stage to November when you said there was 1, and now in February there are 0. It seems like we're going backwards, not forwards, in the time that's elapsed. How can the public have any confidence that these powers are ever going to be used given that trajectory?
So if I could just, for clarity, Senator, note that Minister Giles' statement referred not specifically to detention orders but to the scheme overall. And I think we've just explained the...
Actually, no, he did say preventive detention specifically in his quote. Let me quote, which is the last stage before a matter can go to a court for a court to make an order of preventive detention.
Senator...
You're not responsible for the former minister, who is no longer the minister for a good reason, but, I mean, the public is entitled to rely on statements made by ministers and the government about this, and it seems like we're getting further away, not closer, from these powers being used.
So, Senator, I would only say that the terminology, the complexity of this is such that it may well have been that the minister meant the scheme more generally, because it's difficult for us at the stage of collating the information and going to experts to determine whether it would be a detention order or a supervision order that we were seeking.
How much staff hours have been spent on preparing these cases over the last 15 or 16 months since the legislation was passed?
We've had a task force established since I guess the first staff went into it immediately after the legislation passed in December 2023, and we've had a task force staffed ever since.
And you've given evidence previously about how many people are in that team, but it's quite a large number?
Yeah. Yes.
How many?
There are currently 45 staff in it.
Right, so let's not assume they've all been there that whole time, but 45 staff working for up to 15 months and nothing to show for it?
I think that depends on how you define nothing to show for it.
Well, I would define it as actions that have protected the community. So
we have a much deeper knowledge of the offending profile of those, and we've gathered up a lot more intelligence about the community safety risk posed by individuals that we're prioritising through this.
But this legislation wasn't passed for an intelligence collection purpose. It was passed to remove people who are dangerous in the community out of the community, and that hasn't happened.
It certainly imposes very strict requirements on those who are tasked with implementing it to gather up a very detailed amount of knowledge, and only to file an application if it's in the case of detention where there's a high degree of probability on the basis of admissible evidence that there is no other less restrictive measure available that would prevent the person's risk to the community.
What I'm getting at is given all the time and resources and effort that's gone to this without a single CSO or detention order being applied for, shouldn't at some point over that year we thought, is further legislative amendment necessary to make this process easier? Like the Parliament's been sitting, if this bar is so high, couldn't the bar have been lowered to make the task of your team easier?
Senator, I think as I described before, this has been a process of us understanding and learning what we need to do to get to the point where we can lodge an application. And to pick up Ms Sharp's point, that work will not be wasted when we get to a point where we're able to lodge such an application.
Give me confidence that we're going to arrive at that at some point, because every time I ask about this, I'm told it's not too far away, progress has been made, and every time we return to this, it doesn't appear like any progress has been made. I don't want to diminish the work of the team. I'm sure they're very diligently applying themselves, but from the public's point of view, there's, I think, 279 of this cohort out of detention at the moment with the last update. None of them have been preventively detained.
Just another factor that makes this scheme, I mean, I've told you about a lot of the challenges of the scheme, but just one further one is the existence, side by side with the bridging visa, are visa conditions. So unlike the high-risk terrorism offenders scheme, we have to be able to demonstrate that a community safety supervision order, for example, is needed even though the person has electronic monitoring and curfew applied to them. And then we need to show that those two things are not sufficient. So it just makes the leap that bit higher, because we have to show that those things,
even with those things,
there's still an unacceptable community safety risk that we need to manage.
With indulgence,
Yeah, of
Chair. Just from a legal point of view, in terms of managing the issue, you've had this task force working on this diligently, and as Senator Patterson said, I'm sure they are working diligently. At some point in time, have you circled the wagons, if I can put it that way, considered where you're up to, and considered whether or not you should simply lodge an application and test the law and see what the result of that is? Because at least at that stage, you'd perhaps get a better sense from the courts as to whether or not you're meeting the relevant evidential boundaries or not, and that could inform potentially an amendment of legislation, because it just seems to me it's a long period of time, Secretary, and I guess I'm directing the question to you, Secretary, in terms of taking a helicopter view of this process. Have you given thought to that?
So, Senator, we have given thought to where's the sweet spot, if I can put it that way, between lodging and testing and actually meeting all of our obligations to lodge, and an understandable desire for us to build a successful case, to test the provisions successfully. We're also very conscious, and I know that the circumstances of the cohorts are different, but we're also really conscious of the time it took to build the first cases in the Harto scheme, which arguably are a little more straightforward in terms of the nature of the offences that were being considered. And so, yes, it feels like a long time, and I'm sure it feels like a long time to the team involved in it as well.
Well, it is a long time.
But when we compare it to the 3 years that it took to lodge the first Harto case, that gives us some perspective on what we're trying to achieve.
I hope it's not going to take 3 years to lodge the first preventive detention order. I mean, the key difference between the Harto scheme and this scheme is that those people are already detained. They're serving custodial sentences for terrorism offences, and it's a continuing detention order to keep them behind bars, whereas this is a preventative detention order to get these people off the streets. And I don't think the public will think this has been a good return on investment for the many millions of dollars of staff hours that would have gone into this. I ask again, Ms Sharp, is there any amendments that the Parliament could make to this legislation to make the task of your team easier in meeting this threshold?
Senator, as you know, the scheme is modelled on the high-risk terrorism offender scheme, because that's the model that the Harto scheme has been tested in the High Court and has been found to be constitutional. Whether there's any amendments that can be made, our assessment is any amendments that you would be making to, for example, reduce the thresholds or reduce the evidentiary burden on the Commonwealth would necessarily increase the constitutional risk. So that would be a matter for government to make that choice. If it wanted to try and redesign and cut the thresholds and increase constitutional risk.
I think we've seen, Senator Patterson, what happens when politicians get involved and start writing legislation with disregard for constitutional risk. Mr Dutton did that a number of times, and that legislation has been thrown out by the High Court.
Minister, legislation which you brought through the Senate has been thrown out by the High Court.
we are here having this discussion because of
Let he without sin
legislation
cast the
Mr.
first
Dutton put in.
stone, Minister.
And maybe this is the point at which I remind you that when Mr. Dutton was the Home Affairs Minister, he released 102 convicted sex offenders from
Minister,
detention.
you gave me
with
a personal...
no monitoring, electronic or otherwise.
Minister, you gave me
He's had a lot to
personal
say in opposition.
assurance in the Senate when I asked you when a previous iteration of the visa legislation for the NZYQ cohort was sound, and you said it was, and it was subsequently struck down by the High Court, so we can all play that game. Let me ask you, Minister, is it satisfactory to the government that 15 months on from this legislation passing, it has not been used once?
It's satisfactory to the government that the department is doing everything they can to seek these orders in a way that are going to hold up in court. It's no more satisfactory that Mr. Dutton released 102 convicted sex offenders from detention when he was the minister, but you never seem to want to talk about that, with no monitoring whatsoever.
We are going to a break in a minute.
Thanks, Chair.
Thanks. The committee is going to suspend for 15 minutes and come back at 9:15. We are releasing OSI. We're hoping to get to the courts, I assume, by hopefully 10 o'clock to allow questions by then. Thank you. its hearing. I think we were about to go to Senator Shoebridge for outcome 3 questions.
Oh, excellent.
And I'll come to you.
Just to go back to the questions on Nauru, I asked you about any involvement by Australia in any facility on Nauru, and the answer I got was Australia only has an interest in Regional Processing Centre 1. So I'm going to ask about Regional Processing Centre 2 and Regional Processing Centre 3.
We can certainly do that, Senator. My understanding is that RPC 1 is the only operational centre.
So does Australia have any ongoing involvement in terms of maintenance or ownership of RPC 2 or RPC 3?
No, Senator.
All right. Is there any proposal to transfer people to Nauru into any one of those 3 regional processing centres?
So, Senator, if we're talking, it depends. If we're talking about the NZYQ cohort,
Correct.
under the third-party reception agreement, that's the focus of your question.
Correct.
No, Senator. The intent is that those people go into the community.
So none of the 3 regional processing centres will be used for any of the NZYQ cohort. Is that the position?
So, Senator, I think part of the evidence earlier was that there might be a brief period on arrival where people are accommodated in...
I think...
Well, let's find out.
I mean, at the end of the day, the accommodation provided by the Government of Nauru is at the discretion of the Government of Nauru. They have indicated they may use some of the sites that were previously regional processing centre sites, but I must sort of reinforce that those sites have been inactive for some time and were essentially demolished and given back to the Government of Nauru for their use.
So they may be sent to a derelict regional processing centre?
No, that's not the evidence. The evidence is that they may use the sites of previous regional processing facilities, but the accommodation that they'll be provided is new accommodation that has been put in place and established by the Government of Nauru for the purpose of this arrangement.
All right. Will that involve any gates and fences and security? Will they be locked in there at any point?
So, Senator, one of the provisions in the visa, and I'll ask Ms Sharp to come and join us again, is around freedom of movement.
All right. But of course, a visa that the Nauruan government gives can be revoked by the Nauruan government, can't it, under Nauruan law? They can revoke the visa.
Senator, that is true. That's just a statement of how any, I guess, sovereign nation works. As part of underpinning all of this is, and we haven't talked a lot about it, is the third country reception arrangement that Australia has struck with Nauru. And a fundamental term of that is that people will have freedom of movement. And similarly, we were talking about chain refoulement earlier, and a fundamental term of the third country reception arrangement itself is non-refoulement. And this kind of goes to what I guess you could characterise as the non-negotiables for the Australian government when it considered what a third country reception agreement needed to look like, ensuring that our international obligations were upheld, and particularly around freedom of movement was crucially important.
But you see, Ms Sharp, you rightly accept that the Nauruan government can cancel a visa when and if it chooses to do so. The only protections you referenced were conditions on the visa. So under Nauruan law, once the visa is cancelled, there are no legal protections, are there? That's the end result. Cancel the visa, none of those protections you took me to
So I think
would withstand the cancelling of the visa, would they?
with apology, I think what I was referencing was that they could change their regulations as a sovereign nation. The actual regulations talk about the circumstances in which they might cancel, that they can, under the current regulations, cancel a visa. And there's only 2 grounds for doing that. The first is that the person fails to return to Nauru within 12 months of departure. And the second is the person is deceased.
And is it your position that there's no other sovereign capacity for Nauru to cancel or revoke those visas? Is that your understanding?
Not under the regulations, and I think I'd just reinforce that the terms of the third country reception arrangement that Nauru signed up to, and as a sovereign nation has decided to enter into, make a series of commitments that are entirely consistent with these regulations. And if Nauru were to, change its mind, if you will, and retract these regulations, then the third country reception arrangement wouldn't be being complied with.
Well, the ink wasn't dry on the agreement, and the Nauruan president said that his intention is to repatriate those individuals to their home countries. So whatever you might want to say about the agreement, the secret agreement, the ink wasn't dry on it, and if it contained a non-refoulement obligation, they're already saying they're not going to be bound by it. That's the fact, isn't it?
I don't think we have anything further to add about the president's the president's comments.
Well, does your translation accord with what I just put to you?
Senator, as we've said earlier this evening, we have a third country reception arrangement and we have regulations that the government of Nauru has made which state very clearly that there will not be chain refoulement.
I'm going to ask some questions about the contract that was awarded to Secure Journeys, which is a subsidiary of the US Multinational Management and Training Corporation, or MTC. Who's best to deal with those? Is it just you, Secretary, or is it Mr. Reynolds and Ms. Holbein? Okay. You said in previous estimates that under this new contract there will be a risk assessment framework developed in collaboration with the department to inform the overall management of detainees, including placement with the immigration detention facility and management of any transport and escort tasks. Has that assessment framework now been developed with MTC, with Secure Journeys, or might be easier to just call them MTC?
Secure Journeys, no, it hasn't. That's still under development between ABF and Secure Journeys.
When does Secure Journeys take control of the facilities?
It's a staggered approach to transition, Senator. So the first centre that is transitioning from Serco to Secure Journeys is Yonge Hill Immigration Detention Centre and Perth Immigration Detention Centre. They will kick off early March.
All right. Is it the intention to have the assessment framework in place by early March?
Yes.
Given we're in late February, where are you up to in terms of getting the assessment framework?
So it's still under development, Senator. I think we're close to it. There's still some things that we will work through with Secure Journeys to ensure that it will meet the requirements that we need to satisfy the conditions of the risk assessment.
Does it contain a definition of critical incident? And if so, does that include self-harm and major disturbances?
So the definitions of our incidents are within our incident reporting guidelines within the ABF. So they fall in under our guidelines. They meet our guidelines in terms of what is critical, what's major.
Will you table a copy of the guidelines?
Yes.
All right. Is ABF still seeking to exclude self-harm and major disturbances from the definition of critical incident?
Senator, I think it would be easier for me to actually provide you a quick rundown of what is critical and what is major. Would that be?
Well, does a critical incident include self-harm?
Yes.
Does it include Does it include a major disturbance or the use of force?
Yes.
Does it include threatened self-harm?
Yes.
And will there be penalties under the contract for the occurrence of critical incidents under MTC's management?
Under Secure Journeys, the contract
Journeys.
that we have with Secure Journeys, and I think this goes to Senator Patterson's questions before about response to incidents, the timeliness of reporting. There's a performance measure under the contract which requires the service provider to notify the department, notify the ABF of an incident that has occurred within the centre. So if it's a major incident, critical incident, they must notify the ABF within 30 minutes of them becoming aware of the incident. That is verbally to us, and they have 1 hour to report it in writing. Of course, then that's a scale, so as it goes to the lower threshold of an incident, they have more time. So it's 1 hour to verbally advise. I think it's 2 hours for the written notification to us.
All right.
So it's about the timeliness of reporting, not the timeliness of them responding to an incident that's occurred within the network.
Can you provide on notice what the relevant contractual elements are for a response to critical incidents and major disturbances, both by definition, if you can, and also what, if any, contractual penalties there are?
So, Senator, there are no contractual... we can't abate Secure Journeys, for example, for an incident that occurs within the centre. We can abate them for not meeting the timeliness of reporting the incident to the ABF.
So...
Just 2 more minutes, Senator Shoebridge.
All right. Well, if you could provide the guideline, whatever information you can on notice, that would be useful.
Yes, I can provide it on notice.
When ABF... Was it ABF who entered into the contract with Secure Journeys?
Yes.
All right. When you did that, were you aware of the evidence that Secure Journeys' parent, MTC, had defrauded the state of Mississippi by engaging in a conspiracy scheme involving bribery, kickbacks, misrepresentation, fraud, concealment, money laundering and other wrongful conduct, and had been required to pay $7.5 million in damages to the state of Mississippi for their conduct? Were you aware of that?
No, we're not aware at the time of the contract being entered into.
Have you become aware of it since?
Yes.
How is it that you failed to take that basic integrity test of a company that, to be quite frank, is notorious for this kind of conduct?
The procurement process that was undertaken had a very robust due diligence process that sits within the procurement process. So all that due diligence was undertaken at the time the procurement process was underway.
But you didn't find out about a major fraud, bribery, kickbacks, misrepresentations, concealment, money laundering with the state of Mississippi, which they'd had to pay $7.5 million in damages for. How did you miss that?
Senator, I don't believe that information was available at the time that the contract was entered into, but I'll take that on notice.
Well,
and
the
confirm.
payment was made in
To share the call,
2019.
Senator Shoebridge. So.
Was Secure Journeys required to disclose any such conduct by it or its parents in the tendering process? Oh, surely there was a disclosure obligation in the tendering process.
Oh, we need to take that on notice, Senator. I was not party to the tender process, but I'll certainly take that on notice for you.
The question is, were they required to disclose? And if so, did they? And if they weren't required to disclose this in the tendering process, how could that be the case?
We'll take it on notice, Senator.
I need to share the call, Senator Shoebridge.
Sorry, just to finalise this.
Senator Shoebridge, I've told you 3 times that I'm going to share the call, and I've given you a 15-minute block to get through
finish my
these
questions on outcome 3 with one more question.
Well, if you've got one more question, I won't be coming back to you on outcome 3.
I'm comfortable with that. Is the Commonwealth aware, is ABF aware of the ongoing case involving a US citizen, Carlos Murillo Vega, who was held in unlawful solitary confinement in immigration detention by MTC in the United States on the erroneous belief that he could be deported? Were you aware of that at the time the tender was granted?
Again, Senator, I'm not aware of it. We would need to take that on notice.
Could you provide the same answers for that?
Come to our attention. Okay. Certainly, we can.
Thank you, Senator Shoebridge. Appreciate that, Senator Patterson.
Thank you, Chair. Returning to the NZYQ cohort, please. The latest community protection summary says there are 282 BVR holders in the community. Can I have an update on that, given that there are at least 3 BVR holders presumably in detention awaiting deportation to Nauru?
Certainly, Senator.
Senator, as of the 31st of January, there were 291 people on a BVR following the High Court ruling in NZYQ.
And does that 291 include the 3 in detention pending deportation to Nauru?
It does, Senator.
Sorry, it does or it doesn't?
It does.
It does.
The data was from the 31st of January.
Oh, I see, because they, it was only after the 31st of January
That's right.
that they... so can you just confirm they are in detention, those 3 people?
Yes, Senator.
So they're in detention awaiting deportation. Just on that, I think the Human Rights Law Centre and others have announced legal action. How much legal action is there in relation to those 3 people? Probably Ms. Sharp question.
Sorry, could you just repeat the question?
Those 3 people that are now in detention, that are supposed to be going to Nauru, the Human Rights Law Centre and I think others have said there'll be legal action in response to that. Is there any legal action afoot? Has any been filed?
Yes, there is. There are 3 matters on foot.
Right. Are they all being represented by the Human Rights Law Centre or by others?
They all have different representatives, Senator.
Okay. And are they currently remaining in immigration detention while that matter is before the courts?
Currently, Senator, all 3 are in immigration detention in Australia. The matters will be run separately, and so it will depend on how the court treats interlocutory hearings and the like as to whether they remain in Australia for the duration of the proceedings or whether people are able to be removed.
Right. Is one of the things their lawyers are seeking is that they be released from immigration detention while their matters be considered?
At this stage, the focus of the proceedings are all on seeking injunctions against removal from Australia.
Did publicly announcing this agreement increase the risk of legal action?
Senator, whether the agreement was published or not, we had to notify the individuals who were affected with the cessation notice to tell them that their bridging visa was ceased. Mm-hmm. That's done under Section 76 AAA of the Migration Act. And as part of that notification, we had to tell them that they'd been issued with a visa to another country. Yep. We also have to give them a removal notice. So I think you couldn't not tell the affected people, at least, that the third country reception arrangement existed, because that is the premise of the cessation event in Section 76 AAA.
Okay. All right. So back to the 291 as at 31 January. How many of that curfew are subject to electronic monitoring and or a specified curfew condition?
Senator, the 31st of January, 70 people had electronic monitoring and 42 had a specified curfew.
Sorry, was it 17?
70.
70?
Yes.
Electronically monitored, and did you say 40?
42.
42 subject to a curfew?
Yes.
Some of those have in the past have been overlapping, both electronically monitored and subject to a curfew?
That's correct, Senator. All 42 on a curfew also had electronic monitoring.
Okay. So that means no more than 70 are subject to either an electronic monitoring or a specified curfew. In other words, as of 31 January, 221 had no curfew and no electronic monitoring.
That's correct.
It's a very substantial majority, about 2/3. Of those 2/3, are any of them incarcerated, and that's why they don't have electronic monitoring or a curfew?
Yes, Senator. So a number are, again, at the 31st of January, 26 were remanded in custody, so they wouldn't have been subject to any discretionary conditions.
Okay, so that leaves us with 190 odd, free in the community, no electronic monitoring, no specified curfew.
I think that math sounds right, Senator.
Yeah, I'm not doing the exact maths just in case.
Without checking it, yeah.
But in the ballpark of, we'll work it out later. Okay. It was reported in late January that Imran Dad, the 33-year-old former ringleader of a child exploitation gang, was released from immigration detention after NZYQ, and upon his release he immediately attempted to groom underage children on social media. Now, he was originally jailed for 6 months in March for breaching his reporting obligations as a registered sex offender, and since he was then released for a second time, he's been charged with family violence and visa breaches. Mr Dad, as it is today, do you know if he's free in the community?
Senator, I'm not able to talk about individual cases.
I can remind you, though, Senator Patterson, that 100% of the 102 convicted sex offenders Mr Dutton released did not have any form of monitoring.
Thanks, Minister.
You always gloss over
That'll
that.
be of great comfort to the parents of the young women who were targeted by this sexual groomer.
No. We are making every effort under the law to monitor these people.
Okay, well, tell me...
It's a great contrast to what Mr Dutton did.
Tell me what monitoring Mr Dad is subject to.
It is a great contrast to what Mr Dutton did when he released 102 convicted sex offenders.
So if you are monitoring...
64 child sex offenders with no monitoring whatsoever.
Thanks, Minister. So if you are monitoring Imran Dad, you should be able to say so. Is he subject to electronic monitoring or specified curfew?
Senator, again, I'm not able to talk about individual cases.
Well, I'm asking the Minister because the Minister said that the government's done everything, so he should be able to reassure the public.
Well, I'm not going to talk about individual cases.
Right, so you can't...
No. The point I'm making is that unlike Mr Dutton, who released 102 sex offenders without any form of monitoring whatsoever, our government has put in place a system of monitoring this cohort who were released because of a High Court decision. And we're imposing that monitoring in a way that stands up to the scrutiny of the court, by the courts. We've acknowledged that we've had to adjust the monitoring system in line with court rulings, but the point I'm making is that across the cohort we have done everything possible to monitor these individuals, which is a stark contrast to the approach Mr Dutton took before he politically campaigned on this issue.
Okay, Mr Thomas, last estimates you told me that 65 people had been charged with a state or territory criminal offence. How many are we up to today?
Senator, again, at 31st of January, 90 current BVR holders in total had at least one charge against them since being granted a BVR.
That's a big increase. People had a busy summer, 35 new people being charged. Not just new chargers, but new former detainees being charged. Is that right?
That's correct, Senator. So that would include anyone released from detention since that time.
Okay. Can you provide a breakdown of the types of new offences that were committed over summer from those 35 people?
I don't have that level of detail in front of me, Senator. I would need to take that on notice.
If you could take that on notice, that would be good. Of those 90, how many of them have been convicted and sentenced as a result of their offending?
Senator, I've only got the outcomes from individual offences. So there's been 82 offences finalised from a state and territory offence perspective and less than 5 Migration Act offences. I just don't have that mapped to individual people. I'm sorry.
So when you say 82 offences have been finalised, does that mean there's been a conviction or a guilty plea or...?
So it's a range of different outcomes. So custodial sentence, suspended sentence, fines, etc. I can give you the breakdown if you would like.
But, yes, please, if you could provide that breakdown.
So 17 offences resulted in a custodial sentence, 5 resulted in a suspended sentence, 23 in a community corrections order, 32 in a fine, and 5 were convicted without penalty. So those, again, are individual offences. They will be across a number of people.
Okay. But you don't know, and there are 26 in custody now, but that could presumably include people who are waiting charges, not people who've just been convicted and are incarcerated.
That's right, Senator, and those people may include people that have also had finalised charges.
So you can't break down that 26 number into the people who are incarcerated because they've been convicted?
No, I can't, Senator, sorry, I don't have that level of detail.
Okay, if you could take it on notice, please. So we've got 190 odd who are free in the community without restriction. How many of those have been convicted of murder or attempted murder?
Senator, I've only got the breakdown for the entire cohort. So of the 291 at the 31st of January, there was 14 who had been convicted previously of murder or attempted murder.
Okay. Sexually based offending, including child sex offences.
90 people.
Assault and other violent offending, including kidnapping and armed robbery.
133 people.
Domestic violence and stalking.
19 people.
Serious drug offending.
21 people.
People smuggling.
7 people.
And low level or no criminality.
7 people.
7. How many of the people convicted of murder or attempted murder are not subject to electronic monitoring or a curfew?
Senator, bear with me. So there's less than 5 with electronic monitoring and less than 5 without curfew, and then the balance of the 14 do not have electronic monitoring or curfew.
So does that mean the majority don't have electronic monitoring or a curfew?
That's correct, Senator.
Okay, but you can't give me the specific number?
No, just because of the less than 5 number of the number with those conditions.
Okay, how about the sex offenders?
So 24 had electronic monitoring and 11 had curfew.
So how many don't?
66 did not have electronic monitoring and 79 did not have a curfew.
Right. It's a very large number of sex offenders with no restrictions. Can you provide an updated breakdown and all the costs incurred to date by the Commonwealth in relation to the NZYQ cohort, including law enforcement costs, payments to the Community Protection Board and any government assistance such as social services and Medicare?
I'll have to ask if the CFO is around and can help me out.
Andrew Harvey, Chief Finance Officer. What was the specific question?
It's for a breakdown of all the costs incurred by the Commonwealth in relation to the NZYQ cohort. It's been provided previously and includes law enforcement costs, Community Protection Board payments, and then government assistance to the former detainees, including social services and Medicare.
Life to date over the last 18
Yes,
months
please.
or so? So the department overall has spent $99.3 million across all activities, 73 million on 0.7 on operating, 1.3 on capital, and 24.3 in administered. Now, what was the specific one you wanted? Litigation, was it?
I would be interested in that, yes.
So the government has spent a total of $22.6 million on NZYQ related litigation. Yep, and for so that's on litigation. And I think you asked about the total CSO scheme costs. Sorry? Which is, so the total CSO scheme costs life to date is $20.0 million, and that's split across legal expenditure, which is 18.6. The immigration policy area is 1.1 and the immigration compliance is 0.3.
So just for clarity, that $18.6 million is the team who are working on preventive detention orders and community safety orders?
Including, it's not just our internal task force, it also includes external counsel and lawyers who've been advising us on the strength of various applications.
So we've spent $18.6 million of taxpayers' money for 0 applications.
To date.
Indeed, we could spend more and still not make applications. How much has been spent on government assistance to the NZYQ cohort, including social services and Medicare?
So on government assistance has been a total life-to-date cost of $2.9 million relating to government assistance overall, and that's $0.5 million in income support payments and $2.5 million in healthcare assistance, including the NDIS.
Okay. And just for all of these numbers, just for clarity, to what date are they?
Oh, I should have said that at start. That's to the 31st of December.
31st of December. So we've had 2 months more of expenditure since. So the total was 99.3 to December. Do you have a rough idea of how much has been expended since then?
No.
No, but it would safely take us over $100 million.
Yeah, I think that is safe to say, actually.
Yep.
Yeah.
I will certainly concede, Senator Patterson, that this government has spent a lot more monitoring people released from detention than Mr Dutton did.
And look at the outcomes. Only 90 of them.
Well, what would you have us do?
Australians.
You say it's terrible that people are released from detention. You say it's terrible that they're monitored. It's basically just everything that we do is terrible. I mean, that's the bottom line.
Well, you
That's
said
your
it,
position.
Minister.
I mean, the hypocrisy of you and Mr Dutton lecturing us when you did nothing to monitor any of the 1,300 criminals Mr Dutton released from immigration detention, and now you want to be high and mighty about this?
If your evidence, Minister, is that you've done a great job managing this, please be my guest in making that argument.
Senator Patterson, we have 3 more agencies before 10:30. We've kept them here because you and, well, not you particularly, but your colleagues have said we need to get to them tonight. They've come from interstate. Do you have more questions for outcome 3?
Chair, I would get through my questions a lot quicker without the editorial comments by the Minister. I share your ambition to get through the program.
It's not my ambition. It's actually just that I have been asking for the last 4 hours whether we should let the courts go. We've kept them here. Now we need to go and ask them questions.
Thanks, Chair. Yep, I understand that. And as I said, the time taken to get through questions is a function of both the questions asked and the answers given. Many answers that I've not asked for have been given by the Minister, and that's meant it's taken longer. I do have some further questions. This is on OSB.
So can I clarify? We are keeping the courts who've travelled interstate so that we can tell them to go home?
No, we intend to get to them. It's my intention anyway. I can't speak for all committee members. Chair, we discussed finishing outcome 3 at 10 o'clock. We haven't got to 10 o'clock yet.
I'm saying to you, we're in a hurry to get there.
I'm also in a hurry.
We're trying to finish as soon as we can, Senator Shoebridge.
I wanted it as early as possible.
Okay. How many illegal ventures and unlawful maritime arrivals have attempted the journey to Australia since May 22?
Senator, good evening. Rear Admiral Brett Sonner, the Commander of Joint Agency Task Force. Since May 2022 to the 31st of December 2024, 27 ventures.
Thank you. How many have made it to Australian mainland or territory?
5, Senator.
How many were turned back?
Turned back, we've got 7, Senator. 7.
7, thank you. How many had its passengers returned to the country of departure?
To the country of departure, 16, Senator, ventures.
Thank you. How many had its passengers taken to a regional processing centre?
12 ventures, Senator.
Thank you. On the 12th of November last year, the ABC reported that traditional owners found 4 men on Croker Island, and the Northern Land Council said the men told the traditional owners they'd paid someone money to be taken to Australia. Can you confirm that was an illegal maritime arrival on Croker Island?
Senator, we had a venture in November, yes.
And were there people smugglers who dropped them off apprehended, or just the arrivals?
Senator, off recollection, it was the 4 that were discovered.
Okay, thank you. On the 29th of November, the Daily Telegraph reported that 9 people have been taken to Naru after they were found seemingly stranded by a roadside on the remote north coast of the Northern Territory on a Tuesday afternoon. And the Home Affairs Minister confirmed, quote, within 24 hours of being apprehended, the individuals concerned were no longer in Australia. Just confirming this was one of those maritime arrivals that made it to the Australian mainland before they were apprehended?
Senator, yes, we had another venture that arrived in Australian mainland.
And how many people were as part of that venture?
Senator, I'd have to take it on notice if I can, please.
Okay. And on that occasion, were the people smugglers who dropped them off apprehended, or just the arrivals?
Again, Senator, there was no apprehension of, actually, when you say people smugglers, I think you are talking about, people smugglers are actually people that we talk about that are actually back organising. Are you talking about people that are actually enabling the transport?
Yeah, who was crewing the boat?
I'd have to take that on notice as well, as to whether we apprehended the crew.
Okay, thank you. On the 5th of December, the Australian reported a vessel carrying, in this case, multiple Chinese nationals had made landfall near Marangrida. I apologise for my pronunciation, in West Arnhem Land. That's one of those instances where they made it to the mainland before being apprehended.
Just what was the date of that, please, again, Senator?
5th of December was the report. I don't know when the arrival was.
Senator, I don't recall. Actually, I can say that there was no venture around the 5th of December.
Okay, so was there a venture that made landfall near Managrida?
Senator, I'm aware of those reports, but at that period of time, there was no evidence of a venture.
Okay, so could that have been an illegal fishing venture instead of being a people smuggling venture?
Yes, Senator, we get a lot of reports that we respond to through the Water Watch system. It may have been, but I can confirm no venture on or around that period of time.
Okay. So how many arrivals did happen in the month before Christmas? If it's not that third one, but you confirm the other two, is it only those other two, or have I missed some?
Senator, in December we had 2 ventures.
2 ventures, and how many in November?
We had 2 ventures in November as well, Senator.
Okay, so I think we've covered the first 2, which would be Croker Island and the other one which wasn't specified. What were the 2 December ventures that made it to the mainland?
I didn't say they made it to the mainland. I said we had 2 ventures.
That was my question.
Yeah.
So how many made it to the mainland in November and December?
So since the 1st of October through to the 31st of December, we've had 1 venture that's reached the mainland.
Okay. Speaking more generally about arrivals, not just ones that made it to the mainland, attempted ventures, do you think there was kind of a bit of an uptick in late last year?
Senator, I wouldn't call it an uptick. I would say to you that, as I've been on the record, we had 16 ventures in 2024, all of which were successfully addressed by OSB.
But in terms of the number of arrivals, you don't think there was a late year summer surge? It was just kind of business as usual?
Well, I'd say that Australia is always a place that people smugglers look to come because it's such an attractive place, and OSB is a modest model that we address it.
That's not an answer to the question. Was there an increased tempo, operational tempo, late last year?
Well, what we saw, Senator, was, as I said, 16 ventures over the 12 months. Our average venture was around about a couple of months, and I wouldn't say that there was any increase in the last period at all.
Okay. How many people are on average on these ventures?
I can't give you an average number. I can give you a total number that we had in 2024, which was 271.
How many were in 2023?
2023, we had 74.
Okay, so that does sound like an increase to me.
Well, your question, Senator, if I relay back, was where we had an increase at the back end of 2024. Yep. What I said is that we had 16 ventures over 2024. Okay. If you compare it to 2023, where we had those numbers, well, definitely I would agree there's an increase between 2023 and 2024.
What do you attribute the increased operational tempo in 2024 compared to 2023 to?
Well, I think, Senator, that we're seeing a lot of geostrategic uncertainty. I mean, you only have to look at the UNHCR evidence that talks about displaced people. In the last 10 years, we've seen that double.
And you think that's the only factor? No other factors?
Well, Senator, there's a lot of factors that we look at on an everyday basis. That's my role as the commander, and we make sure that we are mitigating against all those factors. And I would say that...
Can you set out some other factors then, not just the one factor? What are the other factors that you think contributed?
Well, Senator, we look at a whole bunch of factors. I mean, there's a whole bunch of factors that happen that are out of our control, and we mitigate against them. And as I said, we've had 16 ventures last year, all which were dealt with successfully.
Okay. How many people are currently on Naru that are there as a result of being transferred there by the Australian government?
I'd have to defer you to the department for the current number on Naru.
Someone from ABF or Home Affairs who has that number?
Evidence earlier.
I apologise if I missed it.
93.
Pardon?
93.
93, thank you. How does that compare to recent months? Is it an increase?
No, it's been relatively stable. I'll just have to grab my other folder, Senator, if that's okay.
Thank you, please do. And while you're doing that, a monthly breakdown would be helpful to establish that. Thank you.
As was, Senator, as was provided in evidence earlier today, there has been, where it was relayed how many ventures and how many UMAs were transferred in the last 3 months of this year. Is that helpful?
What will be really helpful is the number of people on Naru as a result of being transferred by the Australian Government by month. It's currently 93. How many in the previous month, and so on and so forth?
I would have to take that on notice.
Okay. Do you have it? Is there any kind of breakdown that you do have in front of you that you can provide now?
Senator, in outcome 2, I gave evidence to say in December, less than 5 UMAs were transferred. In November, 13 UMAs were transferred, and in October, less than 5 were transferred.
Okay. How many? Do you have the December number?
December?
Yep.
Less than 5.
Oh, that was less than 5. Sorry, I missed that. Okay, so then, all right, okay, thank you. That would be fine. Chair, there you go. I'm finished 3 minutes early.
Well done, Senator Patterson. Thank you. That's all the questions we have for that outcome of Home Affairs. Thank you very much. I now call officers from the Federal Circuit and Family Court of Australia, the Federal Court of Australia. I note that we're changing portfolios, so if I can ask Home Affairs officials to leave the room as quickly as possible to facilitate that changeover, and we'll just suspend the broadcast briefly to allow that to happen. We will resume our hearing. I now call officers from the Federal Court. Minister, I don't suppose you have an opening statement, thank goodness. And Ms. Lagos, do you have an opening statement you'd like to make?
No, I don't.
Thank you very much. Senator Shivridge, we'll start with you, and then then I'll hand the call to Senator Scarr.
Thanks for your attendance tonight. There's been significant coverage of the answers that the Federal Court gave to questions asked initially by Senator Hume and then by myself in relation to catering. Do you need me to explain the history?
No, I don't. Thank you, Senator.
There is very deep disquiet about the way in which the Federal Court answered Senator Hume's questions and failed to give just basic accountability of catering costs for judges and registrars and others. So I'm going to give you an open chance, if you like, to address that criticism.
Thank you, Senator. I just wanted to outline from the outset that we literally took the question from Senator Hume to be a question regarding, directed to the Attorney General's Department and directed to expenditure on any functions or official receptions hosted by the department or agencies in the portfolio. We took that literally to mean that referred to the Federal Court of Australia entity, which is a non-corporate listed entity that runs the corporate services on behalf of the Federal Court of Australia, the Federal Circuit and Family Court, and it includes the National Native Title Tribunal. So we were looking at the reference to events receptions hosted by the department or an agency in the portfolio. We differentiated that from the Federal Court of Australia as a judicial, part of its judicial structure, which is made up of the Chief Justice and the judges of the court. And when we were asked subsequently through a question on notice directed by you, Senator, later in that year, a specific question relating to expenditure of events, functions, plenaries and the like, that were undertaken by the Federal Court of Australia, we literally responded to and narrated and provided a very clear outline of all events, all circumstances in which the Federal Court had incurred its own expenditure under its own separate appropriation for events that the Chief Justice and the judges hosted, held, created on behalf of the Federal Court, which are the judges and the Chief Justice of the Federal Court. So that was the point of differentiation. And that is the crystal clear explanation of how we literally responded to each of those questions.
Well, there was an answer given by the Federal Court of Australia in relation to the Federal Court of Australia entity as 0 for catering. And that wasn't even true, was it?
It is true, Senator, because the Federal Court of Australia listed entity is an administrative agency that has been specifically created to provide corporate services on behalf of the court. It does not host or hold its own events in any capacity of it, and we haven't held any event in our own as the listed entity. The Federal Court of Australia, the Federal Circuit and Family Court, conducts those events on behalf of the court, not the entity.
A senator was asking questions about catering done by the Federal Court and the agencies within as one of the agencies within the Attorney General's portfolio, and then rather than provide details about the $100,000 plus a year that the Federal Court judges have had spent on their catering, a narrow interpretation is taken to say, well, the judges don't form part of the Federal Court. Is that right?
No, the judges do form part of the Federal Court. That's the Federal Court of Australia as the court. What they don't form part of is the Federal Court of Australia listed entity, which is an agency within the Attorney General's department.
A senator asks questions about the catering expenses by the Federal Court put to the Attorney General and the Attorney General's department, and rather than tell the senator that actually the judges have about $100,000 a year spent on them for catering and the registrars have about $20,000 a year spent on them on catering, you take the response of saying, well, actually, because it's asked through the Attorney General, I'm going to define that as the Federal Court entity, as the entity reporting to the Attorney General, and we're not going to tell them about the $100,000 spent on judges and the 20-odd grand spent on registrars. Is that what happened?
No, I'm sorry, it is not what happened, because the question as it was framed in Senator Hume's question referred to functions or official receptions hosted by the department or agencies in the portfolio. The Federal Court of Australia, the Federal Circuit and Family Court of Australia are separate statutorily created institutions and are not part of an arm of the executive, and that's how we literally read the question and responded to the question. When the question was specifically asked of the Federal Court of Australia, we responded to it in a comprehensive way and provided all of the outline of the events, functions and internal circumstances in which expenditure had been incurred, and are happy to do so. We accept that it is an open and transparency, it's a question that should be answered because it is about financial administration and expenditure, but we differentiated those held by the court in its own auspice, in its own right, versus anything that was undertaken by the administrative agency that is part of the Attorney General's department. The courts are not part of the Attorney General's infrastructure.
Well, to be clear, the question from Senator Hume was in relation to expenditure on any functions or official receptions, etc., hosted by the department or agencies in the portfolio. Now, almost everybody would believe that the federal court is within the Attorney General's portfolio, but your answer is, oh, the federal court entity, a narrowly defined thing, is in the Attorney General's portfolio, but the court as comprised of the judges falls outside of it. Is that your view?
The Federal Court of Australia is made up of the Chief Justice and the judges of the court.
All right. And the fact that there was a question about catering, which obviously was going to, amongst other things, the federal court entity, it was decided not to tell the senator about, for example, the $7,000 spent on the welcome ceremony for Justice Downs, or the $6,500 spent on the welcome ceremony for Justice Futrell, or the $44,000 spent on a function at Sydney. It was decided they fell outside the terms of the question. Is that right?
Because they were events that were held by the court in its own right.
Well, you see, the federal court entity is defined in the Federal Court Act as being officers of the court and staff of the registries of the court, and that includes registrars, doesn't it?
It does formally include registrars as employees under the Public Service Act, but they are also officers of the federal court with judge-delegated powers and conduct work for the federal court under those judge-delegated powers. But they are formally both.
Well, so they're part of the entity, aren't they?
For employment purposes under the Public Service Act, they are.
Yeah, and for some reason you failed to tell Senator Hume about the $18,500 spent on a registrar's conference, or the other thousands of dollars spent on registrars for catering as well and functions.
Because the registrar's conference is the opportunity for the registrars to come together to deal with practice, procedure and their specific roles and functions, and that is an event, that is a conference that is funded by the federal court.
They are part of the federal court entity, the registrars. They've had thousands of dollars spent on functions, official receptions, etc., and you chose not to tell Senator Hume about them.
No, it wasn't.
Again, I give you the opportunity to provide some kind of reason for not providing this basic level of accountability. Senator Hume asks you about this, and you say zero.
Because the registrar's conference is something that is undertaken for the registrars by the Federal Court of Australia. I'm sorry to be so precise, but it is the differential that must be held between the actual court, that is the judiciary, the Chief Justices and the judges of the court, and things that they do as the Federal Court of Australia, as opposed to things that are undertaken by the administrative agency that employs the registrars for the purposes of the public service, to meet their obligations under the Public Service Act.
You see,
I've been quite repetitive in your line of questioning. Do you have a question to finish this block?
I do. You see, another way of answering the question would have been, well, the federal court entity has, you say, spent nothing on catering and functions, but the federal court actually spends $100,000 plus a year on quite lavishly catered functions for judges and thousands of dollars on registrars, and you could have provided that disclosure, couldn't you?
That disclosure was provided in response to your question that related
after
to the
years and years
expenditure
of
for
not
the
telling
Federal
Senator
Court of
Hume.
Australia.
Years and years of not telling Senator Hume. You see, the federal court oversights appeals on FOI and responses about transparency from the government, and yet we get this. It causes significant concern.
I think you've made your point, Senator Shearidge, and there are 3 more agencies to appear in the next 19 minutes.
Well, Minister, are you comfortable with the federal courts
I'm not
handling
going to
of this
answer. I'm
series
not
of
going to enter
answers
into
over
this.
2
You have asked the same question in slightly different ways
Mm-hmm.
about 10 times in a row, and I suggest
So-
it would
so
be
you-
courteous
you're
to all of the other
comfortable.
witnesses who've hung around here.
You're comfortable.
No, you don't put words in my mouth.
Well, could you answer the question?
No,
Are you
I'm not going to
not
answer your
comfortable?
questions because you just keep saying the same thing over and over, and there are three other agencies who've come here from interstate in some cases, and you're going to run out of time, which is incredibly rude.
Because I've been asking questions about hundreds of thousands of
because you
dollars of
keep
catering
asking
on
the same
judges that wasn't
question.
disclosed, and you
keep
think that's
asking
fine.
the same question.
Hundreds of
over-
thousands of dollars of undisclosed expenditure on judges' functions, and you think that's fine?
I have to share the call, Senator Shoebridge. I'm going to do that now. Senator Scarr.
Thank you. I'm carefully wording my question now, Registrar,
Just don't be
after that. Has the Federal Court of Australia, the controlling entity of the Federal Court of Australia, any judge of the Federal Court of Australia, the Chief Justice of the Federal Court of Australia, or anyone else in any way associated with the Federal Court of Australia made a submission to the statutory review of the merger that created the Federal Circuit and Family Court of Australia?
I think I would need to take that question on notice, Senator. I don't think I can provide that specific response.
Because you don't know the answer, or because you need to obtain information as to whether or not it's appropriate for you to provide a response, Registrar?
I don't have the specifics to be able to respond to that question.
Are you aware of any submission being made by anyone associated? Well, I'll be more particular. Are you aware of any submission being made by the Federal Court of Australia or a judge of the Federal Court of Australia to the statutory review that create into the Federal Circuit and Family Court of Australia?
I don't have any specific information in respect of any submission that would have been made. I've not been directly engaged or involved in any of that process myself.
Well, Registrar, you're clarifying it by saying you don't have any specific information. Do you have any information?
I am aware that that may have occurred, but I don't have any of the detail around it.
Can you please tell me the state of your knowledge?
That I have an awareness through informal, yes, that a submission may have been made, but I don't have any more particulars about in what circumstances and any detail around.
General Counsel?
I'm not aware of any submission having been made, Senator.
Secretary?
A submission by the Federal Court to the FCOA reviewers?
Correct.
I'm not aware.
Or any part of the federal court or the federal court entity or any judge or any...
So I want to be very clear here, Registrar. You are not aware of a submission being made by a judge of the Federal Court of Australia to the statutory review into the merger of the Federal Circuit and Family Court of Australia?
I am aware that a submission was submitted. I don't have the particulars of the circumstances. I'm aware through communications.
What communications are you aware? Through what communications?
Verbal communications.
From whom?
I'm referring to the CEO and Principal Registrar of the FCFCOA.
Of the Federal Circuit and Family Court of Australia?
Yes.
What did they tell you?
That they conveyed to me that a submission had been made.
By whom?
By the Federal Court of Australia.
By a judge of the Federal Court of Australia on behalf of the Federal Court of Australia, or by just a particular judge in their own name?
I really would prefer to take this on notice because I don't have...
What action, Registrar, did you take upon becoming aware of that information? Isn't that something you should be aware of as a Registrar of the Court?
I wasn't involved in any of that process leading up to what has transpired, so I haven't been engaged in that process. It's not been something that has directly involved me.
As a Registrar of the Court, do you think it would have been fit and proper for you to have been informed before a submission was made on behalf of the Federal Court of Australia or by a judge of the Federal Court of Australia in relation to a statutory review into another court, the Federal Circuit and Family Court of Australia? Wouldn't it have been appropriate for communication to be had with you prior to such a submission being made? As registrar.
I am in the role of the CEO and Principal Registrar of the Court. My specific function is to assist the Chief Justice of the Federal Court of Australia in the administrative affairs of the Court. So it is a role that I undertake to assist the Chief Justice and the judges of the Federal Court. So I'm not in a position to respond beyond articulating that aspect.
Well, can I ask you, in discharging your functions as a registrar, were you surprised to hear that a submission had been made by a judge of the Federal Court of Australia into a statutory review of another court and you were not aware of it? Were you surprised?
I'm not in a position to express what my sense of that is, Senator. It's something that I don't have.
Okay, Registrar. I'm not.
Yeah,
Registrar.
sorry,
I'm not. No, it's okay. I'm not going to press the point. Secretary, as Secretary of the Department, when a statutory review is occurring of a court, would you expect the registrar of another court to be aware when a judge of that other court makes a submission to that statutory review?
Senator, I think the best way that I can answer that is this was an independent review conducted by two independent reviewers, quite separate from the department. We provided secretariat staff, but they were reporting to the independent reviewers. We don't have a direct line of sight in terms of the detail of how the review has been conducted. In terms of how submissions were received, I don't have detail about that.
Well, I must say I find it extraordinary, Registrar. I'm going to ask you to take these questions on notice. Who authored the submission? What happened to the submission? Was it in fact withdrawn after it was submitted? What were the circumstances for its withdrawal? Is the submission public? If not, why not? Is it appropriate for a head of jurisdiction to make submissions about the composition, makeup, functions or powers of another court? Is it appropriate for a head of a Chapter 3 court to make submissions on matters that are fundamentally questions of policy for the executive government? And do you have any concern that the making of that submission could in any way undermine confidence in the independence or impartiality of the court by entering into a political policy debate and expressing a view about steps that should be taken? And Secretary, I'm going to put similar questions on notice to you. Thank you, Chair.
Thanks. Is that all the questions we have for the Federal Court of Australia? Okay, thank you very much for appearing today. And our court officers from the Federal Circuit and Family Court of Australia, thank you. Like at 10:28, I'm going to start reading out the statement.
Are they in person? I saw Virginia here. Oh, here they come.
Hi. Hello, Mr. Pringle. How are you?
Thank you. Good evening.
If you have an opening statement, I'll ask you to table it, and I'll hand the call to Senator Scarr for the next 8 minutes.
Thank you. Mr Pringle, did you hear the evidence that the previous witness just gave?
Yes, I think except the very tail end of it as we were making our way in.
Okay. Mr Pringle, did someone from the Federal Circuit and Family Court of Australia contact the Registrar of the Federal Court with respect to a submission made by the Federal Court of Australia or a judge of the Federal Court of Australia into the review of the merger of the Federal Circuit and Family Court of Australia?
In relation to that submission, I had a brief conversation with Ms Lagos after the event.
What was the submission? Who made the submission?
The submission was a submission by the Chief Justice of the Federal Court in relation to the review subject matter.
How did you become aware that that submission had been made?
I was advised by the Chief Justice after he was informed, I believe directly by Chief Justice Mortimer.
The Chief Justice of the Federal Circuit and Family Court of Australia advised you?
Yes.
Okay. And what did he say to you when what did the Chief Justice say to you when they became aware of it?
He expressed his surprise as to the receipt of the submission.
And why was the Chief Justice surprised?
He had no prior knowledge of it, and he was very concerned about the nature and content of it.
Why was the Chief Justice concerned about the nature and content of it?
Because it had proposals in it that very much directed or impacted, if accepted, the structure of the Federal Circuit and Family Court.
Did the Chief Justice consider it inappropriate that the Chief Justice of the Federal Court of Australia should make such a submission?
I think in terms of how far I can take the comments regarding how the Chief Justice felt, it would be difficult, but he definitely expressed some serious concerns.
So then you contacted the Registrar of the Federal Court of Australia?
No. The discussions were only brief between myself and Ms Lagos, and that was well after the event.
So Ms Lagos, and I want to be very careful not in terms of presenting her evidence to you, but as I understood it, she only became aware that the submission had been made after a conversation with someone from the Federal Circuit and Family Court of Australia. Was that conversation, from your recollection, the first time that she became aware that such a submission had been made?
I'm not sure of the timing, Senator, but it appeared to me from that very brief engagement that she had little connection with the events surrounding that submission.
Had she been aware that the submission had been made?
I'm not certain whether she was aware just prior or just after, but in any event, it was fairly clear that she was disconnected in a sense from the process.
To your knowledge, what happened with respect to the submission?
Concerns were raised by the Chief Justice with the reviewers and with Chief Justice of the Federal Court.
Chief Justice Mortimer?
Yes, and following some engagements between those three parties, the submissions were withdrawn.
And were there discussions with anyone else in relation to the submissions? The Secretary appears to have had no knowledge with respect to the fact that that submission was made. Was the department involved in any of those discussions?
You'll have to check with the department on that, I'm afraid, Senator. I was involved with the internal workings within the Federal Circuit and Family Court. Secretary,
are you aware of any of that background?
In terms of the detail of what's been described here, no, I wasn't part of those conversations. But I think I should clarify, when you asked me before, was I aware of whether a submission had been made, I've just recalled that Mr Pringle and I did have a conversation where I didn't have the detail, but he said to me there had been an issue about a submission, but it had been resolved.
Well, Secretary, I asked I mean, that is in the context, with due respect, in the context of the discussion we're having, that is not something, when I asked you a direct question as to whether or not you knew a submission had been made, I find it surprising that that was something you didn't remember after the discussion I had with the Registrar of the Federal Court of Australia. How do you explain that?
No, I do apologise. In the context of, specifically was I aware had a formal submission been made to the inquiry? I had no visibility of that. All I was aware of was a conversation where Mr Pringle had advised me that there had been discussions about a submission, but it had been resolved. And that's the extent of my knowledge.
Okay, well, let's pursue that. So after Mr Pringle advised you of that, what did you do?
Nothing.
Did you contact the Minister or the Minister's office?
No, I did not.
Okay, did the Minister or the Minister's office contact you or anyone in your department, Ms Harvey, or anyone else in relation to this matter?
They did not contact me, no.
Okay, Ms Harvey, just for the Hansard.
Senator, no.
Okay. Mr Pringle, do you know why, as I understand your evidence, the Chief Justice Mortimer actually withdrew her submission? Do you know on what basis she withdrew the submission?
In broad terms, because of the concerns, and I would have to take on notice to explain in more detail, but in broad terms, because of the concerns expressed by Chief Justice Alstergren about both the content and the process surrounding those submissions.
Okay, can I literally, we've only got minutes left, Registrar.
1 minute.
In relation to the review process itself, what has the Chief Justice raised any concerns with respect to the review process, with respect to the settlement of the terms of reference, with respect to an opportunity for the Federal Circuit and Family Court of Australia to review the submissions and give feedback to the independent reviewers? Can you give us any information in that regard?
Yes, in broad terms, throughout the process that was been undertaken since around August last year, from the terms of reference to the survey questions to the access to information regarding the review and any draft of the reviewer's report, those are matters which the Chief Justice has been concerned about not having necessarily adequate visibility about through the review process.
Okay, can you take on notice, please, and just provide details as to the particular concerns the Chief Justice had with respect to that lack of visibility as you refer to it?
Yes, I'll take that on notice. Thank you.
Thank you. Apologies to the National Anti-Corruption Commission. We won't get to you this evening. That's all the time we have for our proceedings today. That concludes today's proceedings. I thank the Minister and the departmental officers for their attendance, as well as Hansard Broadcasting and the Secretariat staff. I'll just get a motion moved to accept tabled documents received today from Senator Scarr. Senators are reminded that written questions on notice should be provided to the Secretariat by 5 p.m. Thursday, the 6th of March 2025. The hearing is now adjourned.